The live stream thing is starting up. I'll give you the countdown in 1 moment. 5, 4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and thanks to counsel for joining us for oral arguments this morning. We are holding court via video conference live streaming, and we're doing the live streaming to fulfill our obligation to hold court in public view, and we're thankful that counsel both of you are participating with us this morning. We will conduct the hearing as in the same manner as we would if we were all together in the courtroom. Each side will have 15 minutes to present your argument. The appellant may reserve up to 5 of your 15 minutes for rebuttal. Believing that is all we need to say at the get-go. Oh, let me add that when counsel is not speaking, if you would mute your microphone in the event that you're shuffling papers or what, that can sometimes be a minor distraction, and we'll try to do the same. Mr. Hibner, please call the first case.
Generation 4 Recycling Group, LLC versus Triumph Aerostructures, LLC, Vought Aircraft Division.
All right, you may proceed.
Thank you, Your Honor. This is Randall Winton here for the plaintiff appellant, Generation 4 Recycling, LLC. We're here before the court today to ask the court to reverse the trial court's grant of summary judgment to the defendant and denial of our motion for partial summary judgment. As the learned judges are no doubt aware from the papers that have been filed, this cause of action comes about from a request for proposal generated by the defendant's Triumph Aerostructures.
Excuse me, sir. Are you going to reserve some rebuttal time?
That would be my intention, Your Honor.
Okay, you need to let us know, yeah.
Okay, at the front, I'm sorry. Yes, all things equal, I'd like to reserve 5 minutes for rebuttal.
All right, we'll reset the clock then. Thank you. Please continue.
Okay.
Thank you, Judge Stevens.
The request for proposal that was issued by the defendants in the fall of 2005 contained in it language that they put in as they drafted the document that is called the confidentiality provision, section 8 of the RFP, stating that Triumph will maintain strict confidentiality of all information that you provide in response to this RFP. Triumph will not disclose information concerning your response to this RFP to anyone. In response to that RFP, I believe they asked for 8 parties to respond to it, 3 of which did. My client, Generation 4, submitted the lowest bid in response to that RFP in November of 2015. Sometime around December 15th of 2015, by the client's own, the defense's own documents, they solicited further bids from the other 2 bidders, stating in the communication to those 2 other bidders that they were not the low bidders and telling them the percentage by which their bid was higher than the average of the low bids from the other 2 bidders. Generation 4 contends that this disclosure violated the confidentiality provision by disclosing their information to the other 2 bidders in violation of section 8 of the confidentiality agreement of the RFP. In our complaint, we assert 2 causes of action based upon this breach of the confidentiality provision. The breach itself, that they violated their own confidentiality provision by disclosing our client's bid to the other 2 bidders, and that they were unjustly enriched by the disclosure of that information to the other 2 bidders. At the trial
So
court,
can you
Did either of
discuss?
the other two bidders increase their bid after the alleged disclosure of your confidential information?
Your Honors, the defendant went through 4 rounds of bids after the initial, 4 rounds of bid, including the 4. And by their own documentation, they indicated that they had achieved, and with further negotiation could achieve another 1 to 2 cents per pound of scrap metal being recycled as a result of negotiations. And the
Mr. Whitman, I'm not sure I understand the answer. I would think it would be a yes or no answer.
We believe that it did, Your Honor. They went through 4 rounds of bids, 3 rounds after the one that we responded to. We believe that they, contacted, and by their own admission, they contacted 2 other bidders and told them the percentage that their bid was above what the lowest bid, average bid was at that point in time, giving them an unfair advantage, letting them go back and rebid. Their own analysis showed that they had achieved savings by this additional 3 rounds of bidding, somewhere between 1 and 2 cents per pound, based upon the average number of pounds that they were guesstimating they would be processing. That's about 600,000 pounds a month, or $6,000 in savings per month, 72,000 per year, 504,000 over the 7-year life of the contract.
All right,
And so what are your client's damages in this instance?
We believe that our client was damaged to the extent that they achieved unjust enrichment by being able to get other lower bids from the other 2 bidders as a result of us submitting a low bid based upon the confidentiality agreement that we understood was a part of the RFP. We believe that
So you're trying to recover the savings that Vought received as a result of selecting another bidder?
We believe that they used our information in order to get that, and we believe they were unjustly enriched by cause of that.
I don't know if you answered what he asked, though. I mean, what sort of money are you asking for? What is the character of the compensation you're seeking?
We believe that the defendant, Triumph Aerostructures, saved at least $500,000 over the contract because of them being able to get a lower bid.
Okay. Now, as I understand it, your client took itself out of the process after the first bid. Is that right?
No, Your Honor, we dispute that. That's what the defendant would try and have you believe. My clients got emails, which are part of the record, that shows that as late as in January of 2016, he was contacting the company to see what the status of the bidding process was.
Did you submit another bid after the first bid?
No, Your Honor, they came back and asked us for additional information.
So the answer is no?
As far as submitting a second bid, yes, Your Honor.
Okay. Okay, thank you. And it went on for a number of rounds after that.
Yes, sir. We believe that at least 4 rounds of bidding took place.
So how do you causally tie your loss to a process that went on after you pulled out?
They used our bid to incentivize the 2 other bidders to continue making bids beyond the first round. We were the low bidder at the first round. They disclosed to the other 2 bidders the average of the bids, including our low bid.
They used your amount, the amount of your bid.
Yes, sir.
Was price the only criteria here for selecting the winning bidder? Weren't there other criteria?
No, the defendant rightly states that they had other criteria that they looked at, but before they entered into the RFP process, I believe they had pre-qualified and to some level all of the potential contenders in the bidding process. So, it's our position that any of the bidders could have handled the contract.
I'm still a little confused about the damages issue here. You're saying that under an unjust enrichment theory that you would be able to recover the savings that were achieved by selecting another recycler. But why wouldn't the damages be your lost profits as a result of not being the winning bidder?
I believe that gets into the issue about whether the RFP is treated as a contract or a quasi-contract. We are taking the position as a quasi-contract. Their defendant's own language in the RFP states that it's not a contract, it's only an invitation for bids. If it's a quasi-contract, we are taking the unjust enrichment position, and that we believe that Triumph was unjustly enriched by at least the $500,000 that I alluded to earlier. If we are looking at it, and the trier of fact is looking at it as a real bona fide contract, the RFP that being, then yes, I think after the first round, we were the low bidder. We were capable of handling the contract. And in that case, arguably the trier of fact could find that the damages were the lost profits on the entire contract and not just the savings.
All right. Anything further, Mr. Winton?
Let's see. Presumably the language in the RFP about strict confidentiality was inserted in there on a belief by the defendant that they would get lower bids if people felt that they were comfortable giving their lowest bid and knowing that it would be held in confidence. We are of the position that there's no reasonable argument that says that our request for partial summary judgment that they violated that confidentiality provision exists. And also that we continued expressing interest in communicating about our continued interest in the contract so that we had never actually withdrawn from the bidding process.
All right. Thank you, Mr. Winton. Your first 10 minutes are up. We'll hear from you on rebuttal. Mr. Farringer, you have the floor.
Thank you, Your Honor, and good morning. John Farringer on behalf of the defendant and appellee Triumph Aerostructures. Triumph respectfully submits that the Chancery Court be affirmed on all grounds. First, Generation 4, with respect to its first count, failed to, at the summary judgment stage, to present evidence of any damages caused by the alleged breach. And we've heard a little discussion about that. We'll get back into it. And then second, on the second cause of action, Generation 4 cannot demonstrate an unjust enrichment claim for two reasons. First, because there's a written contract, and we'll talk about that law. And second, because there was no benefit conferred. So let's start first with the breach of contract claim, the first one. And I want to be clear about this because it plays into count 2. Generation 4 alleges a valid written contract. That's what their count 1 is based on. They try to cherry pick out section 8.0 and ignore section 9.0 and other sections, but they allege a valid written contract, and Triumph agrees. The RFP in response is a valid written contract, and the Chancery Court specifically found, in its opinion, as a factual finding, that there was a valid written contract based on that. So both parties agree.
Based on what now?
Excuse me?
There was a valid contract based on?
The RFP and the response created a valid contract. By responding to the RFP, Generation 4 accepted the terms set forth in the request for proposal.
Okay.
And gave their response. And I think it's page 8 of the Chancery Court's opinion. He specifically finds that. And that distinguishes all the cases Generation 4 cites on the unjust enrichment, where there was a dispute about whether there's a contract. And I'll return to that in a minute.
Oh, but you mean just insofar as the confidentiality provision is concerned?
Yes, we agree that that provision was in the RFP. And that we argued that the December 15th emails as a matter of law did not violate it. Generation 4 argued they did, and the Chancery Court said there was a factual dispute on that issue.
Okay.
So basically on count one, on the breach of contract, we're traveling under the second part of the Rye test. We're saying the Generation 4's evidence was insufficient at the summary judgment stage to establish damages caused by any alleged breach. And because of that, I want to real briefly go through the procedural history of the case, because I think it's relevant there. Generation 4 was allowed to amend 3 times, once to avoid our motion to dismiss in the beginning, again right before our summary judgment deadline, which is why we didn't win our first summary judgment. And it was an evolving cause of action. It was first, it started about an oral contract. We disproved that. Then it moved to a written contract. We addressed that, and now it's unjust enrichment. So I mentioned that only to say, when we're talking about the burden of establishing the final amendment, the third amendment was after all discovery had closed. And, we'd argued a couple of different legal arguments, all discovery is closed. And in count one, in that third amended complaint, all that Generation 4 says for damages is, quote, the plaintiff suffered damages. There's no specificity at all. So when we moved for summary judgment on causation and damages, we called them out on that and said there's no proof of what their damages are. So the response were 2 separate affidavits from Mr. Giampetro, the president and owner of Generation 4, and the only damages he identified were his cost to prepare the RFP. He talked about expenses for traveling to Tennessee and hours spent responding to the RFP.
Those affidavits mention nothing about lost profits as a result of not being the winning bidder, correct?
No, that's correct. There is no evidence in the record of what their lost profits even might be. The only evidence in the record, and this is where the Rye burden is important, is those 2 affidavits. That's the only evidence in the record. And so at the summary judgment stage, the only evidence that the plaintiffs have come up with is the expenses to respond to the RFP on the breach of contract claim. So there are 2 problems with that category of damages. And the first is section 9.0, right after section 8.0, the RFP says expenses related to the preparation of the proposal are entirely the responsibility of your company. So the same contract that we both say exists specifically says you don't get those damages. And we cite some Tennessee law in our brief that the court doesn't get to rewrite the contract, plaintiff doesn't get to rewrite the contract. You got to take all the provisions together. And that was the clear intent of that contract, which the Chancery Court found the RFP was a contract. Second, all of those damages occurred before the alleged breach. And again, we cite a bunch of Tennessee cases on that. The alleged improper disclosure, the alleged breach, was these December 15th emails. On December 13th, after December 13th, Generation 4 didn't spend any more time on this bid. And that's where I want to address Judge Dinkins' question about those emails and whether they withdrew. We think they did clearly withdraw, and that's how Triumph took it. But I want to be clear that the Chancery Court did not base its opinion on a finding that the December 13th email was Generation 4 withdrawing. We argued that, and I think it's an alternative ground to uphold it, but that's not what the Chancery Court used that email for. What the Chancery Court used that email for is to show that it was undisputed after that email where Generation 4 says, we're not going to devote any more time. They didn't devote any more time. And so whether they were withdrawing or not, the key point is, as of December 13th, 2 days before the alleged breach, Generation 4 did not spend any more time or money. So this sole category of damages that they allege for the breach of contract all predates the alleged breach, so it can't be recovered. So I'd like to turn to the unjust enrichment claim, unless there are any questions on the breach of contract. We submit, there's 2 grounds for dismissal, and both were found by the Chancery Court as alternative grounds. One is, as a matter of law, if there is a contract governing the parties' relationship, then you cannot have an unjust enrichment claim. And there's a bunch of cases cited. We can talk about any of them. It lays out the 5 elements of an unjust enrichment claim. And one of the 5 elements is there must be no existing enforceable contract between the parties covering the same subject matter. The Doherty case spends a page going over Tennessee Supreme Court and Court of Appeals law, and says the foregoing makes clear that one of the underlying requirements for stating an unjust enrichment claim is that there's no valid existing contract. So we think, as I mentioned earlier, the plaintiff's cases are distinguishable because there was a dispute over a contract, and here there is not. Secondarily,
I'm afraid you're freezing up, Mr. Behringer. We've lost you temporarily. Are you back? Mr. Behringer, can you hear
yes,
me?
I'm sorry.
That's quite all right. Just wanted you to know that we lost
I'm
you.
going to dial in on my phone. Hold on a second. I'm sorry, Your Honors.
It's quite all right.
I'm going to, apparently my internet's weak right now. I'm going to join on my phone, if that's okay.
That'll be fine. We'll certainly extend some flexibility under these unusual circumstances. We realize technology does wonderful things, but then it also has limitations, like a lot of people.
Okay, I'm going to leave the meeting here and I'll join on my phone. I'm sorry.
That's the story of my life.
All right, we have officially lost him, but I guess he'll come back. Let's hang on for a minute, everyone. This would be a great opportunity for Mr. Whitten to make a profound argument when Mr. Behringer couldn't respond, but that wouldn't be fair, so we won't allow that.
He said he's going to call in, Judge Clement.
Very good. That was Mr. Hibner saying he's going to call in. There we go, Mr. Behringer. Welcome back.
Okay, I'm sorry about that, Your Honors. And of course, I haven't had any connection problems in weeks, and the one time I needed.
That's always the way it is. That's always the way it is.
While you were gone, Mr. Whitten made some excellent points. I think you should know, but
Well, I'll guess at what they were since we've been at this a while. So
all right.
just as a technical matter, on my phone, I'm only seeing the person talking. I don't know how to change that view. So I apologize if I speak over one of the judges.
That's all right. We'll work with you. You may proceed.
If I may, when did I cut off, Your Honors? I was talking about unjust enrichment. Did you hear that part?
Yes.
You had talked about the fact that there cannot be a contract, and if there is, then the claim of unjust enrichment is barred. And then you started to talk about the second point. Okay,
thank you. So again, there's a lot of case law. We can go back and forth on that. But the alternative ground of the Chancery Court was that there was no benefit. And this was addressed a little bit in questions of Mr. Whitten. And this is really the first part of the right test, that the evidence affirmatively negates one of the elements. So at this point, we've got I guess now our second logistical problem with this hearing, that talking about the specific numbers in the bid is, in a public hearing, we've been trying to avoid that the whole time, because this is a competitor of Generation 4 who won the bid. Because of our requirements of confidentiality under the RFP, we've been very careful to keep parts of the record under seal. I tried in our brief to pinpoint exactly where you can find these documents, but I can walk anybody through it right now as well. The key documents to look at are this PowerPoint presentation that Ms. Kepley gave to the decision makers. And Mr. Whitten already referred to that, and it's what both sides refer to show the 4 bids and the decision making. And Ms. Kepley confirmed it was accurate. Then there's the actual contract entered into with Northeast Georgia. And really the most important part of that is the statement of work attached to the contract, which contains the actual numbers in the final contract. So if you break those down, it's clear that there was no change in the bid
after round 2. And the briefing of Generation 4 keeps jumping back to look at round 1 versus round 4. And that's just inappropriate, because after round 1, Triumph changed the required capital investment for new vacuums from 2.8 million to 1.2 million. So with that change between round 1 and 2, everybody's numbers changed. And that change predates and has nothing to do with these December 15th emails. In particular, it's in the record, Northeast Georgia submitted their round 2 bid after this change on December 9th. So that's before any alleged disclosure. So that change from round 1 to 2 has nothing to do with the alleged disclosure. Between round 2 and 4.
Did the RFP make provision for this type of adjustment in the requirements of the contract so that the bidders knew that there would likely be these multiple rounds?
I don't think the RFP said exactly how many rounds there would be, but it never said the opposite. It didn't say this was we're just going to take the lowest bidder. As I believe Judge McBrayer, you mentioned, there were 12 factors to look at. And that's where, again, our alternative grounds, not necessarily what the Chancery Court found, but this idea that, well, we were the low bidder, so we obviously won, is not appropriate. And that Ms. Kepley testified at length about that. And as soon as the December 13th email came out saying, well, we're not going to respond any further, and we're adding additional conditions to our original bid, whatever was intended by that, in Ms. Kepley's mind, Generation 4 was not going to win. That was not the sort of a party that they wanted to contract with. So there were a number of factors. We think that RFP clearly contemplated multiple rounds of bids. And in arguing about the alleged breach, which is not really part of the issue on appeal, we cited a couple cases where the average of all bids was mentioned, and it's not a problem. And plaintiff has never cited any case to say the average of all bids is a disclosure of any specific person's prices. So I hope that addresses your question. So again, if you look at round 2 versus round 4 versus the final contract entered into, and I'm trying to avoid saying the numbers, but the numbers are all exactly the same for Northeast Georgia. So there was no benefit conferred by any alleged disclosure. On this issue of the trying this parenthetical in the PowerPoint, it's on page 10 of the PowerPoint if you have it in front of you, trying to negotiate an additional 1 cent for savings if the volume exceeded 42.
All right, Mr. Farringer, you seem to have frozen again.
Yes, he has frozen.
Am I back?
You're back now. Thank you.
I apologize, Your Honors. Next time I'll go to the office.
You talked about the monetary bid of Northeast Georgia never changed, and then you started talking about a 1 cent factor, and that's when I lost you.
Okay, I apologize. That's the latest argument, is this kind of parenthetical footnote about trying to negotiate an additional cent savings on high volume over 42 billion pounds. The evidence shows in the final contract that was never achieved. So whatever hope there was to get that additional savings, it was never achieved. And putting that aside, there's no evidence in the record of this, whatever, if that volume was ever reached, if there was ever over 42 billion pounds. So again, the burden is on plaintiffs. So this new theory, they don't meet their burden on that either. And again, these are alternative grounds for dismissing the unjust enrichment. One is the legal ground that there's a contract, and 2 is the fact that there's no benefit. And Your Honors, with this view, I'm not able to see the timer on my phone, so I don't know how much time I have left.
1 minute and 20 seconds.
Okay, thank you. So, I'll conclude by saying, again, the importance of the RIE test and the standards. We travel under 2 different theories versus on the different claims here, but the case law is clear. You can't alternatively proceed on breach of contract and unjust enrichment when there's no dispute that a contract exists. So we believe this is really a breach of contract case, and there's no recoverable damages proved, and it should be dismissed. If it's not a contract case, if this court were to reverse the change in court's finding that there is a valid contract, there are 2 grounds for dismissing the unjust enrichment claim. So obviously it goes without saying that we submit that the portion of the opinion affirm or denying Generation 4's motion for partial summary judgment should also be affirmed for the same reasons. Unless there's any other questions, that's all I have.
All right. Thank you, Mr. Farringer. We'll now hear from Mr. Whitten.
Thank you, Your Honor. Can you hear me again? I've just unmuted my.
Yes, I can hear you.
Okay. A couple of things by way of rebuttal. Section 8.0 of the RFP, if the court finds that that's a completed contract and not just a RFP, they violated the disclosure agreements in our client's position, either whether it was an RFP or if it was a completed contract. Section 9 of that same document, RFP document, states that it is not a contract. The exact language says this RFP is not an offer to enter into an agreement with any supplier. This is simply a request to receive proposals from suppliers interested in supplying products to Triumph. We reserve the right to accept or reject any proposal when to enter into negotiations with any party to provide these services. So the defendant's own words suggest that it's not a contract.
Well, Mr. Winton, you're the one that brought the lawsuit. What do you say it is?
In our opinion, it's not. We rely on the language in the RFP and the fact that they went through additional rounds of bidding beyond the RFP before a contract was awarded.
Okay.
Something else that they.
So does that mean you're left with the unjust enrichment, equitable cause of action?
That is our position, but we believe the trier of fact would have to decide whether it was really a completed contract or whether it was a quasi-contract unjust enrichment situation.
Okay, thank you.
Something else the defendants haven't addressed, their parenthetical notation on the exhibit that we've been talking about says that they're looking to achieve another 1 to 2 cent savings, implying that they'd already achieved 1 or 2. And there's a question there, why would they go through 4 rounds of bidding if they didn't think that they were going to achieve anything by doing so? And section 9 that says that the RFP is not a contract, it's just a request for bids, also states in there that the bidders can't recover the cost of preparing their bids. We think that that's kind of arguing out of both sides of their mouths as well. If they violated section 8 of the RFP by breaching the confidentiality agreement, then there ought to be some redress that would allow bidders to, at the minimum, recover the cost of preparing the bid. And since our position is that they used our low bid to gain additional savings from the other bidders, we extrapolate that into the unjust enrichment that they enjoyed by getting a lower price by their own analysis. Unless there's other questions, I believe that's all the additional comments I had, Your Honors.
All right. Thank you, Mr. Whitten. Hearing no further questions, we thank both of you for your arguments this morning, and that concludes this case. Mr. Hibner.
This honorable court is now in recess.
Very good. Counsel.